So anyway, that is why question 32 is messed up, is because number 3 should have been wrong, and the answer should have been 1, 2, 4, and 5, but not 3. And that was not a choice. So if you got that wrong, then you actually got it right. 747. A fact-finding hearing in a PIN shall commence not more than 3 days after the filing of a petition under Article 7 if respondent is in detention. The respondent in a proceeding under FCA Article 7 is in detention. The court may adjourn the fact-find hearing on its own motion for not more than 3 days. True. On the motion of petitioner for not more than 3 days. So that's wrong because it's only petitioner. 3 successive adjournments may be granted under special circumstances. That's true. And 4 is wrong because it's got to be on the record. So the answer here should have been 1 and 3, but not 2 and 4. And number 34, let's see what the answer key said. Number 34, it said D. And that's true. Good. 716. Proceedings under FCA Article 7 are a county where the acts alleged occurred. So the venue in Article 7 is like in criminal. It's where the acts or act occurred. Okay, so 36 is a repeat. So 37, 720 sub 3, detention of a person alleged to be or adjudicated of PINs generally shall be only authorized in 1, a foster care program certified by OCFS. Yep. 2, a certified or approved family boarding home. Yep. 3 is absolutely not, because there's no secure facility detention in this article. So no. So the answer was B. 1, 2 only. If a child in custody is brought before a family court judge before an Article 7 is filed, before an Article 7 petition is filed, the court shall hold a hearing for the purpose of making a preliminary determination of whether the child should be, no, nothing to do with detention, it's about jurisdiction. In general, unless respondent waives a determination that probable cause exists, no detention may last more than 3 days. So again, remember, if you're unsure in this Article 7, guess 3 days. Number 40, which of the following are false? At the conclusion of a dispositional hearing on petition for commitment of guardianship and custody of the child, it's 1, dismissing petition, yep. Suspending judgment, yes. Committing guardianship and custody of the child in accordance with 634, that they can't do it after the 18th birthday unless child consents. That's also true. An order of disposition shall be made pursuant to FCA 5 and 631 solely on best interest of child, and there's no reason, and something about, 40. So yeah, so this is, these are all false. I'm sorry, none of them are false, which is why the answer is D. So the only thing that was messed up about this question is that it said FCA 5. I think it just meant to say FCA 631. But anyway, again, this was a false. It was looking for which is false. So if you put A for this, you knew all the answers, you just didn't read the question carefully. So that's not good. So this question I got wrong when I took the test. And it's because I got the suspended judgment portion wrong. So now I know that in FCA Article 6, the maximum duration of an extension is only 1 year. So 2 is wrong. 1 is correct. The rules of court shall determine permissible terms and conditions of a suspended judgment. Yes. The maximum duration of a suspended judgment is 1 year unless the court finds at the conclusion of the period that exceptional circumstances require an extension for an additional period up to 1 year, not 2 years. So 2 is false. The order of suspended judgment must set forth the duration and terms of conditions of the suspended judgment and must contain a date certain for court review not less than 30 days prior to the expiration of the period of suspended judgment. Number 41 says B. So that is true. And number 4, not later than 60 days prior to the expiration of the period of suspended judgment, the petitioner shall file a report with family court and all parties, including the respondent and his attorney or her attorney, the child's attorney, and any interveners regarding the respondent's compliance with the terms of the judgment, suspended judgment. The report shall be reviewed on the court date, and that is true. So ACD can be on court's own motion or any party for a period not to exceed 6 months. That's what this question says. And number 42 is true. Now, I get messed up sometimes who can ask for the ACD on certain ones, but anyway. This one, again, I got wrong because it was about suspended judgment. At the conclusion of the dispositional hearing under FCA 8, the court may order it. The court may. It's either dismiss the petition if the allegations are not established. That's good. The suspended judgment, number 2, is wrong because it's 6 months. Okay. 3 is correct, 1 year probation. 4 is correct, order of protection. 5 is correct, restitution up to 10 grand. So the answer was everything except 2. Okay, because it's a 6-month suspended judgment in that question. And order of protection under 841 shall set forth reasonable conditions of behavior to be observed for a period not in excess of 2 years by petitioner or respondent, or for a period in excess of 5 years upon a finding of the court on the record of aggravating circumstances.